It is time to check in with Chris Dimakos, our CJAD 800 legal contributor. And Chris, boy, talk about timely. We talked about this story about a week ago. It's come up in the news again, specifically in Quebec, at least the particular story where the government is asking employees to come back to the office from 2 days a week. I think the ask is 3, and the reaction, of course, has been very negative. I think the last number I saw showed 90-some-odd% of Quebec civil servants don't want to come back, don't feel the need to go back. But the story is rulings, you say, are now starting to come in on employers who are forcing employees to come back to the office, kind of end that whole remote work situation. What are you starting to see?
We're starting to see the courts actually sanction employers that are calling employees back to work, and they're not doing so, which what the courts feel are against what the law provides for. So, for example, we had an employee who's been with the company for many years, and when COVID hit, they had them working remote up until 2025, and then they called the employee back full-time 5 days a week, and the employee says, well, I just moved. I moved homes. I'm farther away. It's a 100-kilometer commute to come to work every day. There's no way that I can do that right now. We have to make some accommodations for me. The employer said, no, that's not the contract. The contract is you work in office, and COVID was COVID, but now you have to come back. And what the court said was, when you do that, it's almost like you're firing the employee, a constructive dismissal. You're basically telling the employee, too bad for you. If you don't like it, you can leave. And that's pushing them out the door. And they awarded the employee the same amount of money as they would have been had they just outright fired the employee without cause. So the courts are saying, look, if you're going to send employees to work remotely or even a hybrid model, and you want to call them back, you have to give them a lot of notice, reasonable notice, to have them make arrangements in their life to see if they can actually come back to work on a 5-day basis. And if not, if the situation has changed to the point where it's no longer feasible for them to come into work, well, then a discussion has to be had, and they have to try and accommodate the employee. Now, does that mean an employee who was told to go and work remote for 12 months after COVID that went and moved away to another country? There are limits to how much accommodation an employer has to do. But the main thing that I'm seeing now with all these rulings is that they're saying the employees made decisions, and they made life decisions based on what the new normal was. And if the employer wants to claw that back now, you have to give sufficient time and accommodation to try and work with the employees. It's not, they didn't ask to be put on remote at the time with COVID, but now we're asking them to come back. You have to accommodate them to the best of your ability.
So we're kind of in uncharted territory here, right? Because COVID changed everything with respect to the employer-employee relationship, how many days here, how many days whatever. So with respect to these rulings, Chris, do the courts stipulate what actually constitutes, reasonable warning or a reasonable,
You're absolutely right. That's such a good question, because the court, that's one of the main struggles that they had. And they said, we're going to treat this. The more time an employee spends working remote or hybrid, the more likelihood that part of the contract that wasn't written before becomes terms of the contract. So, for example, if you have an employee that's been working remote for 5 or 6 years, and now you decided that you wanted them to come back, the court says, well, 5 or 6 years is a long time to be working remote. It's almost as if it's in the contract now. It's a contract term that might have not been written or typed up in the computer, but it's there now. It's established now that they're working remotely or in a hybrid model. So to answer your question, which is I think at the heart of the issue, is how does the court look at it? How do they put a fence around this, and how do they lay the foundation to rule on these cases? They look at it like the longer you spend working remote, the more time you spend in a hybrid or a remote model, the more likelihood that becomes new terms of your contract, even if it's not written on paper, even if it's not signed. If the employee starts to rely on it and it starts to become the new normal, there's a greater chance that now becomes terms of your contract. And if you want to change that as an employer, you're going to have to work with the employee and try and figure out a solution to that. But not only on that point, but there are times where people that were working remote before COVID, they got letters from the employer saying, we have a new policy, everyone's coming back to the office. And they're saying, well, 1 second here, I was working remote for the last 20 years. You can't expect me to come back to the office now because you have this new mandate. to call everyone back. And those employees went to court, and those employees were successful in saying, I was always a remote employee. I mean, now they're telling me to come back to work. That's changing fundamentally what my contract is. So, the word you use, uncharted territories, you're absolutely right. But rulings are starting to come in right now, and they're starting to shape how employers and employers are going to navigate this call back to office, and especially if the employee's been there for several years working remotely. If I was representing an employer, I'd be tread carefully. You don't want to be too aggressive on this because you can find yourself end up paying some substantial money in the form of a severance.
So if you're an employer and you force your employees to come back, you're going to be in trouble, despite the fact you could say, look, I've changed employment, terms in terms of where you can work. You need to come back. This is the new strategy for the company. You can't just go ahead and do that, irrespective of what we're now seeing versus court decisions.
You cannot. And what the strategy now is, and if I'm representing the employers, the strategy is, if you're going to do that, you have to provide the employee with sufficient notice. So let's say you want to be careful. You're like, you know what? We want you to come back to the office. We understand you've made decisions. You might have relocated kids, daycares, schools, all that. We understand that. So we're giving you a sufficient notice, not weeks, maybe not even months, maybe even over a year, but saying eventually this job is going to be back in the office. And if you give sufficient notice in the court size, then that's enough for the employer to tell the employee, you got to come back. Okay. And the employee then can make a decision. Either I want to or I don't want to, but I still have 8 or 10 or 12 months to think about this and how I'm going to do this.
Well, what about just a hypothetical, Chris, right, where the employee's like, you know what, I really like working from home in terms of productivity. I'm being as productive or more productive, and whatever job assessment report they have proves that. What if you just don't want to go back? What are your options then as an employee?
Right, and if you're an employee and you don't want to go back, well, and you say, listen, the terms right now, based on where I'm at and where I'm at, it's not feasible for me to come back to work on a full-time basis. At that point, it's almost as if a discussion should be had about, as if it would be a termination. So I'm not coming back. I cannot come back under those terms. And the employer can either say, fine, well, we accept, you can continue working, or the employer is going to say, sorry, we can't accept that. The only option here is for you to come back. And if you can't, well, then we have to discuss what it's going to take to have you go and give you something that's sufficient in the eyes of the law in terms of a severance. So your discussion would shift from, we can't make this work to, okay, I'm not coming back. Let's talk about me being pushed out the door, because that's what's happening here. It's not like you decided to trigger this. You didn't resign. You had a change, a fundamental change to your contract terms, even if they're not written, and now you have to discuss what it's going to cost for you to go.
So just as a last question here, as always, I think this happens more often than not when we talk about these kinds of things. This is not black and white. Every employee, I guess, has a different situation. So as always, Chris, is this a matter of sitting down and negotiating before you just make a decision one way or the other, either employee or employee?
You're absolutely, yeah. So what I strongly recommend, employment law it involves people and involves situations and real life situations, corporate and these other kinds of law, paper and numbers. Not when it comes to employment. You get the laws and you get people with actual unique scenarios. So what you want to do first and foremost is find out, what are your legal rights? What exactly does the law say about your particular situation? And once you understand that, and once you understand the risks involved, you can sit down and have a conversation with your employer and say, well, here's what the law says, and I want to make sure that I'm aligning myself with what the law says. So you can do this or you can't do that. But the information that you need to have is so important, because that's going to dictate how you're going to negotiate afterwards.
We'll leave it at that. Chris, thank you so much. Appreciate it.
Thanks, Aaron.
Introducing Bryan Adams Radio on iHeartRadio. Hosted by Bryan Adams himself.
Join me for an insider look on a wild ride through 40 years of global rock and roll.
Bryan Adams Radio. Now available on the free iHeartRadio app. Or ask your smart speaker to play Bryan Adams Radio on iHeartRadio.
Who's ready to rock?
Kids wanna rock.